Alright, so in this case we're looking at remoteness. So the focus is basically that the damage can't be too remote from the event itself. It's there in order to prevent an unfair imposition of liability. So first we can look at intervening acts of third parties. So you're basically looking to see, was there any break in the chain of causation? Is this damage as a result of something else that occurred in the middle of these events? So you can talk about intentional acts of wrongdoing. So a good case here is Lamb. So there was a burst water pipe, they had to clear the house for repairs, and squatters went in. And they said it was foreseeable that squatters would go into an abandoned home and cause extensive damage. However, the council can't be responsible for this because the squatters are strangers. They're not in control or liable for their actions. We can also look at negligent intervention. So Knightley and Johns is a very good case here. So the defendant overturned their car in a tunnel. Police come, they try to close off that tunnel, make sure no one can go through it to prevent an accident. However, the police tells the other one to drive through the tunnel in the opposite direction from traffic to go to the other side and close off the other side. It was an extremely negligent decision to do so. There would be cars coming, which did, and there was an accident that occurred. The defendant wouldn't be able to foresee these external actions of the police making such a decision and causing this damage. They can't be found liable for that. It's an external negligence that they can't foresee. Also, we can look at intervening acts of the claimant. So, did the claimant break the chain of causation by how they acted? So, in McHugh, they descended the staircase, the claimant, that didn't have a rail, and they were holding a child where they did so. However, after the claimant's accident from the original defendant, their leg gave way a lot, and they knew this was a possibility that going down the stairs, their leg would give way and they may fall. They did fall, and it was unreasonable for the claimant to act in this way. They shouldn't have gone down this stair with a child without a rail where they know this happens. It's separate events. They broke the chain of causation here. The defendant's no longer liable for this. Wyland's quite different. So there was an accident. She had a collar and couldn't wear her glasses for this reason. She needed help to go home. She even called her son, I think, who came with her. And as she was going down the stairs, she fell. Here, the claimant did everything she possibly could. She acted very reasonably. And an important thing is, it was the same series of events. There wasn't a change anywhere. It was from the accident to the hospital to her way home. There was no break in the chain here. We can then look at Spencer. So there was an accident and he ended up having to amputate his leg. He had to wear a prosthetic leg and he had to take this off when he was driving. He couldn't wear it while driving. I think he was putting petrol in or something like that. It was quite a short journey and he chose not to put on his leg while going out, and he fell in this process. Here it was held that this wasn't a break in the chain of causation. It was the same series. However, they did admit that the claimant had made misjudgment here and contributed to this. We can move on to Emma. So here the claimant wanted to have a sterilization operation. This was done negligently. She ended up actually getting pregnant and she gave birth to a baby with many abnormalities that required constant care. The defendants basically argued that she didn't get an abortion, and so that broke the chain of causation. However, the courts looked at it as the operation was there for the purpose of preventing the pregnancy, which it didn't do. The fact that she got pregnant as a result of this failure and didn't get an abortion doesn't break the chain of causation. It's still the same chain of events. It's one series. And so there was no break. We can then look at Reeves. So in Reeves, there was a prisoner and the guards were aware that he was at risk of suicide. They negligently left the flap open and failed their duty to prevent protect from this specific risk which they knew existed. And they said here that this is clearly not a break in the chain. They knew this risk had existed. They knew they had to protect from it. However, they did provide the defense of contributing negligence to the police in this case. I think it was something like 70%. It was a large decrease in the damages. However, the main focus here is there wasn't a break in the chain of causation. If you're aware of this specific risk and it's your duty to protect against it, you must do so. The claimant acting in a way that you're aware of won't break the chain. Right. There's also a lot of cases where the tort interferes with the mental stability of the claimant. So in McCreamer, he suffered in an accident resulting in personality change. I think he had petty crimes, but nothing major. And he ended up sexually assaulting 3 women. And the argument was, but for me being in this accident, I wouldn't have suffered a personality change. I wouldn't be committing crime now. And so he should have a claim on this. However, also the main thing was he was given the defense, the criminal defense of, I think, what's it called? Diminished responsibility. So the argument was he can't have it in criminal but not in civil. However, on the grounds of public policy, they didn't allow the claim. They said, where your actions are illegal, you've done something wrong, we can't compensate you for that. And that same mentality applies in Gray. So he was in a train accident, he suffered PTSD and depression, resulting in a personality change. He got in a fight with a homeless man, went to his girlfriend's father's house, took out a knife, ended up stabbing the man to death. And he's saying, again, but for me being in this accident, I wouldn't have suffered this personality change, I wouldn't have done this. But the courts held you cannot receive compensation for illegal activity. It goes against public policy to allow this. Imagine being compensated for committing crime. It wouldn't fly in the society. A change from this is Core. So in Core, they suffered a head injury which led to their depression and they ended up committing suicide. And they said that it's foreseeable that as a result of depression, you'd commit suicide and this depression was suffered from the accident. The main reason I think this has been decided separately is because it was a suicide. It wasn't a murder. They didn't act against another human being. And so it had a different outcome. Again, you have to look at the facts of each individual case. Don't just look at it as, okay, it's something completely different. It's foreseeable. It leads on from one another. Alright, so again, discussing foreseeability, which is the big focus. You have to establish that that specific type of harm was foreseeable. A good case for this is the wagon mound. So here there was an oil spill, and then that resulted in a fire. But the fire was caused by a spark which was from a very small risk. It was almost negligible. And so they said that that specific type of harm was unforeseeable. Maybe you'd foresee someone slipping, but you wouldn't have seen that spark occurring and causing a fire. And so they held it was unforeseeable there. We then lead on to Hughes. Here there was a manhole, it was left open, but they surrounded it by paraffin lamps in order to, I think, bring attention to it. Don't go fall in that. And a child picked this up and fell in. And as they fell in, I think the paraffin lamp exploded. It was very unforeseeable that this would happen. It was such a small risk. It was strange that it actually happened. However, the court said you can foresee harm by burning. All that's required is that you foresee the kind of damage or the nature of the damage, not the specific damage itself. So if it's along those lines, the claimant's able to have a successful claim. You can then move on to dirty. And in this case, an asbestos cover fell into a hot liquid. This exploded, it then splashed and harmed the claimant. However, it wouldn't have been reasonably foreseeable at that time that this would occur from these series of events. Same kind of thing in Joey. So there's boys playing with a boat in a park, falls on them, injures one of the boys severely, and it was said that you can foresee that kids are going to go towards this and play with it. They can foresee personal injury, not the extent of it, but they could foresee the personal injury and should have acted in a manner to prevent this. They should have removed it. These two cases basically focus on the idea that you have to foresee the way that the damage is caused. If you wouldn't foresee that series resulting in this damage, it's going to be an unlikely claim. You wouldn't have foreseen it. Alright, lastly, we're looking at the eggshell skull rule. This basically says, take your victim as they are. So you don't have to establish, as a claimant, you won't have to establish the extent of the injury had to be reasonably foreseeable. All you have to show is you could foresee my injury. So a case here is Smith. So the claimant had hypersensitivity, they were burnt on the lip by a splash of molten metal, and this triggered the cancer, and they were predisposed to cancer. And the argument is that we would never have foreseen that you were predisposed to cancer, and this resulted in that. We can't be liable to pay for that. However, the courts held you only have to foresee the injury itself, not the extent of it. It's unfair to the claimant to stop their claim just because it goes beyond something that another person might have suffered. Right. This has been a relatively short lecture, but I think main focus is just look at the cases, understand them so you know when to apply them to certain cases. The facts will always be very different. It's the underlying message. So why was this case decided this way? If you can wrap your head around that, you'll be able to use these cases a lot in questions.